you today? So, today we are live to talk about a more serious topic. Um, but before we start, just a couple of housekeeping items. First of all, I am testing some volume adjustments with the little buffers I have for like the intro and the outro and the countdown. Um, so we will see if those are working and adjust accordingly. And secondly, I feel like there should be some trigger warning. I can't speak. Why does that say captioners? I mean, why does a captioner say children? Shit, I can't speak or think apparently. I meant to say, I think there should be some trigger warnings. Fuck, my mouth. I don't know. For the topics because we're gonna be discussing some heavy stuff, but I'm not really sure what I'm gonna talk about or how much I'm gonna talk about today in relation to the trigger warnings. So I'm going to just hold off and put that in the description at the end of the live stream when I know what the fuck I talked about specifically, you know what I mean? And as we go, if I recognize, catch that we're going into a topic, I might, try an alert to that. But yeah, overall, we will be speaking on some issues related to let's see, what are the charges here? Um, just related to criminal sentencing, related to theft, related to fraud, um, related to forgery, related to abuse, more specifically child abuse. That will come up later. Um, Drugs and substance abuse are also going to be mentioned in the live stream. And so I know that some of those things will be brought up, and I expect other things could potentially be brought up as well. So yeah, just a couple of warnings, I guess. But today, what we're going to be discussing um, would be a situation regarding someone named Tajuana Thornton, also known as Tajuana Thomas, and middle name is Marie. Um, and so we're going to be discussing a case regarding this person. I really want to look at this as a case study regarding value alignment. And a lot of the social issues we talk about are typically related to human rights issues, but also I kind of want to look at how interpersonal relationships can be ways we can look at upholding um, possible problematic situations. And I just kind of want to take a look at what allows certain behavior to perpetuate within society. You know what I'm saying? And so typically we've been doing that through the use of businesses as case studies. But I do kind of feel that because this person was charged on a felony count related to telecommunications fraud, if I understood that correctly, we're going to pull up the document, which will have the correct charge on there. I may not have said that right. Um, but yeah, I just kind of feel like looking at like, because how do businesses become harmful, right? It's individuals in the business. So then I think when we can kind of understand different case studies for how individuals make the decisions they make, or why what we observe of them making in relation to others who have done similar things, we can kind of then see how certain things can be perpetuated in society, or the common factors people who do similar things have. You know what I'm saying? I think it's interesting to observe just in terms of thinking of long term, how do we change social issues? Um, and I also, I don't know if this is appropriate comparison to make or not, because they are different cases in a lot of ways, but I do think there is a lot to compare here with the some similarities too between Tajuana and GRB. I'm gonna say her name one time to know who we're referring to, Gypsy Rose Blanchard. I'm gonna just refer to her as GRB because the first name is a technical slur. that I don't feel appropriate just repeating throughout. So I'm going to try to just use her initials. Because I don't want to trigger. There's another trigger warning. I don't want to trigger anybody on that slur as well that may be impacted by that word. Because that must suck ass. You know what I'm saying? Like for the normalization of it with the naming right there. You know what I mean? Um, So right there, yeah. But anyway, okay, I'm gonna roll my intro. And then what we're gonna do is look at fucking some court case documents and some information online about what's been published in public record regarding a certain individual, as well as a court case regarding those felony charges that I was bringing up earlier. And we're gonna look at from another arrest that was, I believe, was put on the same person about 4 years later, I think. We're going to see the timeline as well when we see the documents. Um, and then I also found a document from what I believe could be this person's childhood. And so we'll take a look at that and we'll kind of reflect on how that may have contributed to the behavior of today. Um, and then yeah, after that, I think I'm gonna just kind of do my comparison um, on GRB. And you know what? That reminds me, I'm looking up something real quick. I apologize. So, I'm feeling gaslit right now. If I remember correctly, GRB claimed that she had indigenous um, ancestry, and now, okay, I found it. All right, I apologize. I'm gonna add a link here to. Um, I'm sorry, I'm starting off slow. I should have. Okay, so just one. There's another similarity I believe I just found between GRB um, and the Tajuana Thornton situation. Okay, I apologize for that. Now we're really gonna do this fucking bitch. I'm gonna roll my fucking intro and then let's get started. I apologize. Hi, my name is Lexi, aka Deaf Child. I'm born deaf, hard of hearing. My team was one of the top teams between 2020 and 2024 in New Orleans and Louisiana. I began doing business as Deaf Child in 2013, marketing 2011, and sales 2009. I've earned 50 plus certifications in marketing and sales, and I have my Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Visit my site at noladeafchild.com. Okay, so first, what I would like to take a look at is directing our attention to the Supreme Court from Ohio document from their clerk of court. Um, this was filed on July 13th, 2017, case number 2017-0949. Um, and this is regarding State of Ohio versus Tajuana Thornton. And I kind of just want to do a reading, commentary, and reaction to this document here. It is linked in the description of the video for those who need that access. Um, or who just don't even want to listen to my bullshit, it's linked it. My sources for all this information, if you don't even want to watch the video or listen to me speak, you can go look at the description of the video and read this information yourself. Um, but yes, otherwise, buckle in. I've got chocolate milk. Let's do this bitch. So the beginning of this document starts with a table of contents, and you'll find that in the table of contents here we have an explanation of why this case is a case of public or great general interest or involves a substantial constitutional question. We have statement of the case and facts, argument in support of propositions of law. Then we have proposition of law number 1 under RC 2929.18. A trial court may order a defendant to pay restitution to the victim from whom she stole, and an appellate court properly reviews the restitution order under an abuse of discretion standard. We have a conclusion as well as a proof of service. So let's begin with the explanation of why this case is a case of public or great general interest or involves a substantial constitutional question. It is well settled that the purpose of restitution as part of a criminal sentence in a theft case is both compensatory and punitive. Yet the First District disagrees. The issue before the court was simple: whether it was proper for the trial court to order the defendant, who stole money directly from her victim's bank accounts, to repay them as part of her sentence. The First District found that it was not. This decision neutralizes the punishment that restitution is, in part, designed to impose and represents a clear example of impermissible judicial activism. The purpose of restitution is not merely to make the victim whole, but is also meant to punish the offender and contribute to her rehabilitation, while being disturbed not by the defendant's criminal behavior, but by the idea of a crime victim receiving a potential windfall. The First District has thoughtfully ensured a windfall for thieves, rewarding their misconduct by allowing them to keep their ill-gotten gains, and undoubtedly encouraging similar criminal conduct in the future. So, and just to reflect, if I interpreted this information correctly, they are saying that Tajuana stole money, and at the time that this was written, was not made to have paid the money she stole back. She didn't have to do that from the court. Got it. And what they're saying is that, from my understanding, if I interpreted this correctly, is that this could be part of what perpetuates and normalizes that behavior. Okay. And then it says, the First District's decision turned the principle of restitution on its head when it held that the trial court had no authority to order Thornton to pay restitution to her victims. Is it this the Gurks? I'm so sorry, I don't know how to say their names. The Gurks. I think it's the Gurks. The court's decision, because it is composed of 2 concurring opinions and 3 disparate perspectives of the law, reveals the obvious discomfort of at least 2 of its writers with the inane result, which is viscerally repugnant, morally offensive, and just plain bad public policy. I don't think I said inane right, viscerally right, or repugnant right. I don't think I'm speaking correctly today. Let's keep going. But most significantly, it is not at all supported by a plain reading of the statute it relies on. The Ohio Revised Code empowers a court to order an offender to pay restitution to her victim and in an amount based upon the victim's economic loss. I wonder if she did this again to someone else, if this would apply to them as well in a different state. RC 2929.18 A1. The statute defines restitution simply in terms of the loss to the victim occasioned by the conduct of the defendant. It contemplates a simple binary analysis, which is the relationship between but two parties, the defendant and the victim of her crime. It requires no analysis qualifying the victim's loss or anticipating actions or civil remedies involving third-party benefactors. So, to sum it up, I think this paragraph, to sum it up, is basically just saying it's fucking bullshit that she's not paying that shit back. She needs to pay that fucking shit back because some bitches were harmed. What the fuck? In my opinion, I think that is the summary. Moving on. But the first district ignored the plain language of RC 2929.18 and instead inserted language that is not there, obliterating the legitimate goal of restitution and compelling consideration of outside actions by third parties not before the bar and not at all contemplated by the statute. Indeed, the legislators streamlined the analysis in 2004 when it removed the references to all parties, with a few exceptions not at issue here. The intent of the legislator is clear from the statute: allow thieves to pay back their victims and allow third parties to exercise their rights to recovery from the party they paid. To demand consideration of civil remedies like unjust enrichment, quantum merit, and subrogation unnecessarily burdens courts and parties by requiring inquiries that are not contemplated by the simple model set up by the legislator. Such remedies can be pursued outside of this forum. Okay, on one level, I kind of understand how would the whole purpose of there being technical terms is that there needs to be a word that specifically defines just one specific fucking thing, because that's how you understand that this is what you are speaking on for a specific issue, right? That's like the whole point of semantics and arguing semantics is understanding and communication, right? So I get on one level, in any field, terminology relevant to that field is very important. However, when it comes to the way legalese is worded, I really think they make this shit fucking confusing on purpose so we don't know what the fuck they're talking about. Because what the fuck is this? How are you gonna be like, I'm letting the public know about this case for public interest, but the public doesn't know what the fuck you're talking about? You know what I mean? Okay, I need a fucking attorney on this bitch. But my understanding, right, of this information is basically the first district court is saying that this is burdening them. In my opinion, like, I can't tell with this wording if they're saying that the first district court used language to claim this, that they are not, that this is unnecessarily burdening courts. If this paragraph is saying that the first district court is claiming that, then I think that's real fucked up, because how the fuck is providing justice to victims a burden on you when that's your fucking job? But if I'm getting the wrong interpretation of that, which is very most likely what I'm doing because I'm not an attorney, and if they're saying, you know, that they're demanding consideration of shit that doesn't need to be considered in relationship to this, and that's what's the unburden and that's what's unnecessarily burdening the court, then I can get it. And it's not about that, then I can get it, you know? So because I don't know enough about the law, I don't know what the correct interpretation of that wording is there. And both of those suggestions could be entirely wrong as well. But those are the two meanings that I took from this shit fuckery of wording. Um, so, you let that marinate, let that reflect what the fuck you think that means. Continuing. The majority also recognized the current split of authority among Ohio courts on the standard of review to be applied when reviewing the imposition of restitution and felony sentences. Prior to its decision in the instant case, the First District utilized an abuse of discretion standard. But here, the court announced that, in light of its interpretation of this court's decision in State versus Markham, 146 Ohio, blah, 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 the proper standard of review is whether the sentence is clearly and convincingly contrary to law. But the state submits that Markham was limited to sentencing term challenges and plainly does not apply to orders of restitution. So here, I guess they're just arguing what case law should apply to here. Not ordering, arguing which case law should apply. In my opinion, perhaps, based on that. And then it says, thieves, by their nature, believe that they are entitled to the property of others. The First District has just told them that they are right. The state requests that this court accept jurisdiction over this matter to tell them they are not. Okay, so I do know what the definition of jurisdiction means, and that is a court's authority to rule over a subject area. So that reminds me, I have a toxic TikTok. I think it was a TikTok mock trial bingo card that I've been using for toxic TikTok trends, and my free square is lack of jurisdiction. I might do a live stream. I honestly might do a live stream where I watch people argue and play toxic and play my bingo. I don't know if that's toxic of me or not. It might be. I might do it. Look, don't judge me. I'm fucked up. Okay, judge me. I'm judging people. All right, now let's look at statement of the case and facts. Here is where I believe we're actually going to find out what happened. Defendant appellate Tajuana Thornton was indicted on 7 felony counts, including theft, forgery, and telecommunications fraud, all felonies of the 5th degree. Thornton pleaded guilty as charged to 1 count of theft in exchange for a dismissal of the remaining counts, and was convicted. Thornton was sentenced to a period of community control in order to pay restitution to the victims of the offense, John and Mary Girk. In a decision on May 31st, 2017, the First District found that the trial court sentence ordering restitution by Thornton to her victims was clearly and convincingly contrary to law, and reversed the trial court's judgment. Wow. State versus Thornton, 2017-Ohio 4037. Although it acknowledges that the Girks were victims of Thornton's crime, the majority found they suffered no economic loss, and that the trial court erred when it ordered Thornton to pay them restitution. If this person offended again, though, then wouldn't they just be perpetuating it? Okay, then it says, the first concurring opinion found the Girks did suffer an economic loss, and that Thornton should not be able to retain the $5,454 she stole, but that a reading of R.C.2929.18A1 required that Thornton keep the money. The second concurring opinion found that the Girks were victims of Thornton's behavior and did suffer an economic loss, at least initially, but because their bank reimbursed them prior to Thornton's sentencing, Thornton cannot be required to pay anyone back. Ah, okay, the bank reimbursed them. Okay, so she should still have to pay for the attorney's fees, I think. Facts. John and Mary Girk had taken Tajuana Thornton into their home to help her. Wow, I wonder if this has happened again. In the summer of 2015, Thornton used this arrangement to gain access to the family's checkbook and online bank accounts. Thornton stole checks from the Girk's checkbook, which she then forged and used to pay her rent elsewhere. So, I wonder if she's gone into someone else's home to get them to help her around. She alleges to live somewhere else. I wonder if this is a recurring theme for her. I wonder. I'm just questioning. Thornton also assessed the Girk's bank accounts online and used their money to pay her own personal bills at Duke Energy, AT&T Wireless, and Progressive Insurance. I would suggest anyone that is still in touch or has been in touch with this person within the last month, check their credit card statement, log out their shit, go into their email, log out all devices, make sure you're good to go. Just track your shit. Just cancel your fucking credit card. Just be safe. All right. In all, Thornton was able to steal $5,454.01 from the Girk family before she was caught. At the sentencing hearing, Thornton was made aware that the Girk's bank had put the money back into their account. Thornton took the position that she did not have to pay back the money she had stolen. Honestly, now I sound like a bootlicker. This is the one time I think a bank should go after somebody. Like, if the bank had to pay them back, why doesn't the bank go after this bitch? You know what I'm saying? Okay. Now we're going to look at argument in support of propositions of law. Proposition of law number 1. Under R.C.2929.18, I don't even know how to fuck say this shit. People who are actually like versed in the law are probably like, why is this bitch saying dot all the time? That's not how you cite this shit. Look, I don't know. Alright? Fuck. Anyway, it says, a trial court may order a defendant to pay restitution to the victim from whom she stole, and an appellate court properly reviews the restitution order under an abuse of discretion standard. On appeal to the First District, Thornton argued that the trial court was wrong to order her to repay her victims, John and Mary Girk, the almost $5,500 she stole from them while she was living in their home. The First District agreed. The state of Ohio respectfully submits that the Court of Appeals analysis regarding the application of R.C.2929.18 is erroneous. Generally, a trial court's order of restitution will not be reversed absent a showing of an abuse of discretion. State versus Williams, 34 Ohio. Oh, this is citing some shit. Okay. An abuse of discretion implies that the trial court's attitude is unreasonable, arbitrary, or unconscionable. In State versus Lalane, the Ohio Supreme Court recognized that a trial court has discretion to order restitution in an appropriate case and may base the amount it orders on a recommendation of the victim. But the amount ordered cannot be greater than the amount of economic loss suffered as a direct and proximate result of the commission of the offense. Pursuant to R.C.2929.18A1, the sentencing court may order a financial sanction in the form of restitution by the offender to the victim of the offender's crime or any survivor of the victim, and an amount based on the victim's economic loss to be paid to the victim or the survivor, the probation department, the clerk of courts, or another agency designated by the court. By definition, a victim is a person or entity harmed by a crime. Black's Law Dictionary, 1703. Damn. Under R.C.2930.01, a victim is defined as a person who is identified as the victim of a crime or specified delinquent act in a police report or in a complaint, indictment, or information that charges the commission of a crime and that provides the basis for the criminal prosecution. Under R.C.2929.01L, economic loss means any economic detriment suffered by a victim as a direct and proximate result of the commission of an offense and includes any loss of income due to lost time at work because of any injury caused to the victim, and any property loss, medical loss, or funeral expense incurred as a result of the commission of the offense. You know, honestly, they should be including the time that they lost at work, having to go to court for all this shit. She should have to pay for that shit. And what about emotional damages? Is that not a thing in Ohio? Does that not apply here? And then it says the Ohio Supreme Court has recognized the dual purposes of restitution in a criminal case. We recognize that although the primary goal of restitution is remedial or compensatory, it also serves punitive purposes. But payment of court-ordered restitution is an obligation, rooted in the traditional responsibility of a state to protect its citizens by enforcing its criminal statutes and to rehabilitate an offender by imposing a criminal sanction intended for that purpose. It thus serves both remedial and punitive purposes. And R.C.2929.28 empowers a court in an exercise of its sentencing discretion to order restitution as part of a criminal sentence. The United States Supreme Court also has pointed out the importance and usefulness of restitution to our justice system. Restitution is an effective rehabilitative penalty because it forces the defendant to confront, in concrete terms, the harms his actions have caused. Such a penalty will affect the defendant differently than a traditional fine, paid to the state as an abstract and impersonal entity, and often calculated without regard to the harm the defendant has caused. Similarly, the direct relation between the harm and the punishment gives restitution a more precise deterrent effect than a traditional fine. Here, the First District failed to recognize the dual purposes of restitution. It was undisputed that the restitution amount involved here is $5,454. It also was undisputed that repayment to the victims of the amount she stole from the Gurks was a condition of the terms of Thornton's community control, and that Thornton would be violated if she failed to make the restitution ordered by the court. At the sentencing hearing, the trial court noted that defense counsel for Thornton was of the opinion that the bank is not entitled to get their money back. The trial court initially responded, so what I'll do is I'll just indicate restitution in that amount to either Fifth Third Bank or the Gurks as appropriate. So if the Gurks get the money back, then they'll just pay Fifth Third Bank. Regarding the money she stole, the trial court told Thornton, you gained it wrongfully and they're entitled to it. At this point, counsel for Thornton protested the order that money be paid to a third party. It est Fifth Third Bank, based on case law, which she cited. The trial court modified its position and ordered Thornton to pay restitution directly to the Gurks. In her direct appeal, despite the fact that she undisputedly caused an economic loss to the Gurks of $5,454, Thornton argued that she should not have to comply with the court-ordered restitution requirements or pay anyone back for the thousands of dollars she stole. Further, she argued that because Fifth Third Bank reimbursed the Gurks, the trial court was not authorized to order her to make restitution to them. Below, the state relied on the First District's decision in State v. Berlinger, where the court held that the trial court properly ordered the defendant to pay restitution to the victim, even where the victim had been reimbursed by a third party. In Berlinger, the First District held that R.C.2929.18A1 authorizes the trial court to award restitution to the victim of an offender's crime or any survivor of the victim in an amount based on the victim's economic loss, and upheld the order of restitution to a victim who had been reimbursed by his insurance company. And the First District also noted that in 2004, the General Assembly amended R.C.2929.18 to remove a trial court's authority to order that restitution be paid to a party other than the victim of an offense, the victim's survivor, or certain agencies designated by the court. In Berlinger, the defendant stole steel valued at $13,148 from Metro Deck Inc. Berlinger, the way they word that is weird. The victim impact statement showed that Metro Deck had been reimbursed in full for the value of the stolen items by its insurer. The trial court ordered Berlinger to pay restitution to Metro Deck for the entire amount of their loss. The First District noted that the trial court ordered that the restitution be paid to the victim, not to the victim's insurer, in accordance with the amendment of the law in 2004. The First District concluded that the trial court, therefore, did not act outside the authority granted to it under R.C.2929.18A1, and the restitution order by the trial court was proper. Berlinger, is it Berlinger or Berlinger? I don't know. Like Thornton, argued that the trial court erred because the victim, Metro Deck, did not suffer any economic loss within the meaning of the statute. The First District disagreed, finding that Metro Deck suffered economic loss in the amount of $13,148. The First District correctly pointed out that the fact that Metro Deck was insured should not redound to the benefit of Berlinger, who caused the economic loss. I don't know, is it Berlinger? It just sounds so off to me. Trial counsel for Thornton argued the situation here was the same. At the sentencing hearing, counsel for Thornton told the court, so my statement is that the bank in this case is like an insurance company paying on behalf of a victim. Accordingly, the state argued on direct appeal that under Berlinger, the trial court was authorized to order Thornton to pay restitution to the Girks in the amount that she stole from them. But the majority in Thornton's case disagreed and found that the trial court sentence ordering her to make restitution to her victims was clearly and convincingly contrary to law and reversed the trial court's decision. State v. Thornton, 2017-Ohio-4037, something else. In doing so, the majority wrongly fixated on the actions of a third-party benefactor, here a bank, whose actions are not contemplated by the language of R.C.2929.18. While acknowledging that the Girks were victims of Thornton's crime, the majority found they suffered no economic loss, since a third party, here a bank, stepped in and compensated them. The court decided that Thornton did not have to pay them, or anyone, back for the money she stole. Thus, according to the majority, a third party can absolve a wrongdoer of any responsibility to make her victim whole, and the majority's misguided preoccupation with any windfall that could result to a crime victim led to this statement. Ordering restitution to the Girks would result in an impermissible windfall and would frustrate the purposes of restitution. But what about frustrating the purposes of laws against stealing from other people's bank accounts? How does ordering a defendant to make her victims whole frustrate the sentence in a theft case? And what about the windfall to the defendant? Inexplicably, the majority also saw fit to mention that the trial court could have imposed a fine of up to $2,500 upon Thornton, implying that it chose not to, as if this helps justify the majority's decision. The majority fails to recognize that a court's first duty should not be to pay itself through fines, but to make whole the victims who come before it. The First District has sent a message to thieves that they are free to do what they wish with the money they steal. Using the majority's rationale, Thornton could have chosen to invest the money, head to a casino, or perhaps put it toward a down payment on a house. Conversely, the court's first concurring opinion found the Girks did suffer an economic loss, and that Thornton should not be able to retain the $5,454 she stole, but that a reading of R.C.292918A1 somehow required that Thornton keep the money. The opinion reasoned that the bank should have been named the victim in the indictment. This opinion went on to suggest that the state should have put on evidence, presumably at the time of the plea or perhaps the sentence, that the victims had a subrogation agreement with their bank, which would add a new twist and an additional burden to the prosecution and the bank and the real victims to theft cases, and that this would have changed the writer's decision. This opinion also pondered that the outcome on appeal would have been different if the record had shown that the Girks suffered another form of collateral economic damage. They suffered from this bullshit. Such speculation makes it clear why the legislature took third parties out of the mix when they rewrote the statute in 2003. Inexplicably, some courts have put them back in, with no statutory authority to do so, and have impossibly muddied the waters of an otherwise uncomplicated issue by initiating senseless inquiries into subrogation agreements or other civil remedies, which would require a trial within a trial on a simple theft case. And finally, the court offered a third analysis and a second concurring opinion. This opinion found that the Gurks were, in fact, victims of Thornton's behavior and did suffer an economic loss. But because a third party came in before Thornton's sentencing and reimbursed them, they did not really suffer an economic loss. This opinion added timing as a consideration in defining economic loss. Here, Thornton gets the benefit and is not required to pay restitution. This opinion requires a moment-by-moment analysis, which appears nowhere in R.C.2929.18 of when the loss occurs and when it stops occurring. This vague, immeasurable, and therefore impractical standard simply cannot be what the legislator intended when it simplified the statute. Let me simplify this shit. The harm starts when she started stealing the money and stopped when she stopped stealing the money. So pay back the fucking money she stole, bitches. Alright, let's go. I apologize. It says loss to a victim is not something that comes and goes. It happens at the time of the crime as a direct and proximate result of the commission of the crime. Yet this opinion, offered by the First District, manufactures from whole cloth an arbitrary timeline for economic loss and frames its parameters, again, with no statutory authority and for no legitimate purpose other than to reward the defendant for her hard work stealing someone else's money. And although this opinion offered justice a consolation prize when it proposed, the bank retains any rights it has to pursue Thornton civilly. It offers no suggestion for a mechanism for such relief. The state further suggests that Thornton should have been barred from the outset from claiming that she cannot be ordered to make restitution to the Gurks, as her claim is a civil one that is based in equity, unjust enrichment, quantum merit, and has no place in a criminal restitution hearing. Even if Thornton could assert such equitable claims, the doctrine of clean hands would bar her, as a convicted criminal defendant, from doing so against her victim, the Gurks. The clean hands doctrine bars a party's equitable claims when the party is found to be at fault. I think I just burped. Sorry. In relation to the other party and in relation to the transaction upon which the claims are based. Thus, Thornton, a criminal offender who has been convicted of theft, should not be permitted to assert equitable claims or defenses against the victim of her crime, as she has unclean hands. The state submits that under either standard, abuse of discretion or contrary to law, the trial court properly ordered the thief in this case to make restitution to her victims. Okay. Conclusion. This court should accept jurisdiction over this matter to direct Ohio courts to reaffirm the intended punitive purpose of restitution by applying the law as written, and to clarify the standard of review to be applied when reviewing the imposition of restitution in felony sentences. And then they served an Ohio public defender on her behalf. So yeah, so this is a filing in the Supreme Court case of Ohio regarding Tajuana Thornton. And next, I would like to direct your attention to the Court of Appeals, First Appellate District of Ohio. So I don't. You know what? I wasn't going to. Oof. Let's see. Okay. I don't think I have it in me to reread the parts of this case here about what we read with the bullshit as to why there is a issue with why they're not arguing why they don't have to pay it back or whatever. But I do want to just get this additional wording and just see if there's anything else in here about the background on the case, the facts of the case, and the conclusion. I believe, if I'm understanding correctly, this is all related to the same case, just different documents in relationship to it. And so yeah, let's check this shit out real quick. Um, and so this one comes from Justia. This is State versus Thornton regarding the Court of Appeals documentation. Okay, so fucking I'm gonna read the introduction and the background now. Let me zoom in on here. I've got low vision. Let's see. Okay. It says, defendant appellant Tajuana Thornton appeals from the judgment of the trial court convicting her of theft under R.C.2913.02A1, a fifth-degree felony, sentencing her to serve 5 years of community control, and ordering her to pay a $250 fine and $5,454.01 in restitution to the victims, John and Mary Girk. In her sole assignment of error, Thornton asserts that the trial court abused its discretion in ordering her to pay $5,454.01 in restitution. Because we find that the Girks had not suffered an economic loss, we hold that the trial court's order of restitution was contrary to law. We modify the judgment to remove the restitution order and affirm the judgment of the trial court as modified. Background. While living at the home of John and Mary Girk, Thornton, without permission, used a check belonging to the Girks to pay her rent at another location and used their bank account to pay several bills. The Girks reported the funds stolen to the Fifth Third Bank, which reimbursed the Girks $5,454.01, the full amount stolen by Thornton. Thornton was indicted for 2 counts of theft, 1 count of forgery, and 2 counts of telecommunications fraud. The Girks were the only victims listed in the indictment. Thornton waived her right to a jury trial and pleaded guilty to 1 count of theft in violation of R.C.2913.02A1. The trial court accepted her guilty plea. At Thornton's sentencing hearing, after reviewing the victim impact statement, the trial court recognized that Fifth Third Bank had reimbursed the Girks for their loss. The trial court initially ordered that Thornton pay restitution to Fifth Third Bank or to the Girks. Defense counsel remarked that R.C.2929.18 did not permit the trial court to order Thornton to pay restitution to a third party, and that Fifth Third Bank was not a proper victim before the court. The trial court stated, well then, what I'll do is I'll order the Girks to be paid $5,454.01, and I guess it's up to them whether they want to pay the bank back. The trial court explained that it may promote theft if Thornton did not have to pay back the money that she had stolen from the Girks. The trial court entered judgment on count 1, dismissed the other counts, sentenced Thornton to 5 years community control, imposed a $250 fine in court costs, and ordered $5,454.01 in restitution to be paid to the Girks. Thornton filed a motion to stay the order of restitution pending appeal. The trial court denied her motion. Thornton also filed a motion to stay the execution of her sentence with this court, which was also denied. There is assignment of error and standard of review in here. Should I read this? Shit. But if I do, I feel like that's it took me about 40 minutes to read the last one. If I read this, that will put me up another 40 minutes. I'm just going to read the conclusion. If y'all want to read the facts regarding the rest of this case, it is linked in the description of this live stream. So the conclusion. Because the Girks had not suffered an economic loss pursuant to R.C.2929.18, The trial court's order of restitution was contrary to law. Therefore, we reversed that part of the trial court's judgment and modified the judgment to remove the restitution order. The judgment of the trial court is affirmed as modified. Judgment affirmed as modified. Okay, so let's marinate. What we're reading right now came before the first thing we read. The first thing we read came after what we're reading right now. Timeline. Okay. And then it says, it's got some bitches concurring separately. Another dude said, while I disagree that the Gurks did not suffer an economic loss as a result of Thornton's criminal acts, I must accept the result that the award of a restitution in this case was contrary to law. I do not believe that Thornton should reap the benefit of her illegal activity and avoid having to pay restitution in this case. But the Ohio General Assembly eliminated the language in R.C.299.18A1, which permitted the trial court to order restitution to third parties for amounts paid to victims for economic losses. See State versus Aguirre, some other shit. If the bank had been listed as a victim in the indictment or restitution had been made a part of the plea agreement, we would not be having this discussion. But that is not the case. I write separately because some of the cases cited by the majority support the proposition that reimbursement precludes a restitution order involved reimbursement from insurance company. I disagree with those cases and believe our recent case involving restitution and insurance coverage remains good law in this district. In Burlingame, this court upheld an award of restitution to a victim who had been reimbursed by an insurance company. The court held that the victim had suffered an economic loss because premiums had been paid to secure the coverage in an amount that would cover the theft. Burlingame is therefore distinguishable from this case because our record contains nothing to indicate that Girk suffered another form of economic loss other than $5,454.01 vanishing from their bank account. What about the mental and emotional damages? If their record has shown that the Girks had a subrogation agreement with Fifth Third or had suffered another form of collateral economic damage from Thornton's criminal wrongdoing, my decision in this case would be different. Okay, but my opinion is, why are the victims being punished for if their attorneys didn't file something correctly? Should the victims in this case, would that count as like, what is it when your attorneys don't give you competent advice? There's like a word for that. I forget the term. Okay, so someone else concurred separately saying, I too concur. There is no question at the time of the theft that Girks were victims and suffered an economic loss as defined by R.C.299.01. However, by the time of the sentencing, they had been fully reimbursed by their bank. Under R.C.299.18 and Ohio case law, the bank, as the third party, cannot be awarded restitution. And because the Girks ultimately suffered no economic loss, they cannot be awarded restitution either. While this leaves Thornton with no criminal restitution obligation, the result is required by the clear language of the statutes. The bank retains any right as to pursue Thornton civilly. I don't understand how it negates the loss when we're admitting that she stole. You know what I'm saying? But yeah, she doesn't have to pay it back. What? Anyway. So now I just want to bring your attention to fast people searched for the name of Tajuana Thornton. I actually didn't even mean to show the part before. I thought I'd already scrolled down to the also known as names. So that is my bad. But I did link this in the description. This is all public record. Anybody can find anything on here. But I just want to show from the fastpeoplesearch.com where under Tajuana Thornton here, we do have also known as Tajuana Marie Thomas and Tajuana Thomas, Tajuana M. Thomas, as well as Tajuana Thornton, Tajuana M. Odaker, Tajuana Horton, Tajuana M. Thornton, Tajuana M. Odaker, Tajuana Thornton, Tajuana Odakers. And so, yeah, just letting that know. And then there's also previous addresses up in here, too, that connect Tajuana from Florida to Ohio. And you're going to see why that's relevant in a second here. Next, I have from unicourt.com. I want to direct your attention to this little blurb on Thomas Tajuana Marie regarding a case summary where there was a criminal lawsuit filed in Lake County, Florida courts. And let's see here. the case status is pending. It was filed 2022. What we just looked at before, I believe that was 2017. Let me pull that back up. I believe this is 2017. Let's look up here. You gonna show me the fucking dates on this bitch? I thought y'all dated shit. I thought time was important in the law. Come on. Here it is. Yes, 2017. So we're jumping from 2017 to 2022 here. And in 2022, we can see here, we'll just look at the order of events. So, there was an initial arrest from the Eustis Police Department, October 7th, 2022, documented. Um, the descriptions for the charges here include operating while driver's license suspended knowingly, resisting officer, obstructing, I think, is that without violence? I'm not sure if this means with violence or without violence. I think they mean without violence, but I don't know. And narcotic equipment possession and or use. So inebriation may be a thing here. She was bonded out, I believe, or a bond was set. I'm assuming she was bonded out. I think whenever I click view the court documents, it wants me to sign up to view this shit. I'm not doing that. But a uniform traffic citation was filed um, regarding these charges. Fucking, and she was bonded out October 11th, 2022. There was a plea negotiation on the docket. I believe that she pleaded not guilty. I do believe that there was a plea negotiation conference hearing October 31st, 2022, and there was a sentencing November 14th, 2022. The case is still pending, the case status here. I do not know the outcome of the case, what happened with those charges, whether or not they stuck or they were dropped. Even if she pleaded not guilty, because it does look like there were a couple of hearings after that, so that wasn't the end of it. So yeah, that's what we know. And then next here, we've got from Lake Florida, I believe this comes from the same situation. We have a Lake Florida mugshot situation here. It's linked in the description of the video for Tajuana Marie Thomas. And it looks like this is from the same charges, from arrestment from the same police department. So yeah, this is where the cover photo comes from. And so yeah, this would be who we are speaking on today. And you can also look at I do have a Facebook profile that I found linked. I do believe it's the same person. You can make that decision for yourself. And now here's where we come to where I want to put in some trigger warning for child abuse. So here we have in the Matter of Thornton from case text, and this is how did we get here? You know what I'm saying? Why is this situation as it is? How did Tajuana get to where she is today? Well, I found while looking for some information regarding the case, some documentation about it, I found this right here, casetext.com, in the Matter of Thornton. It looks like there was a previous situation where I do believe, I'm just going to read this, and then we'll discuss. So it says, defendant appellant Suzanne Thornton appeals a decision of the Clermont County Court of Common Pleas Juvenile Division granting the motion of appellee Clermont County Department of Human Services for a planned permanent living arrangement for appellant's daughter, Tajuana. On January 6, 1999, CCDHS filed a complaint alleging that Tajuana, born June 26, 1989, was a dependent child. The complaint was filed after Tajuana was hospitalized for stabbing herself. It indicates that appellant's mental state impaired her ability to parent at the time, and that Tajuana's father was out of the home and could not be located. On January 14, 1999, emergency custody was granted to CCDHS. On March 9, 1999, Tajuana was adjudicated a dependent child, and temporary custody was awarded to CCDHS. I'm sorry, I don't know how to say that word. Tajuana remained in the temporary custody of CCDHS and placement with a foster family for over 1 year. On April 6, 2000, CCDHS filed a motion requesting that the court grant a PPLA. The motion stated that reunification efforts were not successful and alleged that parents had significant physical, mental, or psychological problems which rendered them unable to care for Tajuana. The motion also alleged that adoption was not in Tajuana's best interest as she retains a significant relationship with her mother. A hearing was held on May 23, 2000, and the motion for a PPLA was granted by a magistrate. Appellant filed objections to the magistrate's decision, which were overruled by the trial court on July 14, 2000. Appellant appeals the trial court's decision to grant the PPLA and raises the following single assignment of error. The trial court erred to the prejudice of appellant when it ruled in favor of the state's motion requesting a planned permanent living arrangement. Appellant first contends that there was insufficient evidence for the trial court to make a finding of dependency at the March 9, 1999 hearing. Appellee responds to this argument by stating that the March 9, 1999 finding of dependency and award of temporary custody to CCDHS was a final appealable order, and any challenge to that finding is untimely. The Ohio Supreme Court has stated that an adjudication by a juvenile court that a child is neglected or dependent as defined in R.C. Chapter 2151, followed by disposition awarding temporary custody to a public children's services agency pursuant to R.C. 2151 3.353A2 constitutes a final order within the meaning of R.C. 2505.02 and is appealable to the Court of Appeals pursuant to R.C. 2501.02. In Murray, 1990, syllabus, that's some citing shit I can't do right, my bad. Appellant did not timely appeal the March 9, 1999 finding of dependency and award of temporary custody. Therefore, appellant's failure to timely appeal the March 9, 1999 finding of dependency precludes our consideration of this issue. And then it cites something else. Appellant next argues that the trial court's decision to grant the motion for a PPLA was an abuse of discretion. And as applicable to this case, R.C. 2151.353A5 provides that A. If a child is adjudicated an abused, neglected, or dependent child, the court may make any of the following orders of disposition. 5. Place the child in a planned permanent living arrangement with a public children's services agency or private child placing agency. If a public children's services agency or private child placing agency requests the court to place the child in a planned permanent living arrangement, and if the court finds by clear and convincing evidence that a planned permanent living arrangement is in the best interest of the child and that one of the following exists. B. The parents of the child have significant physical, mental, or psychological problems and are unable to care for the child because of those problems. Adoption is not in the best interest of the child, as determined in accordance with Division D of Section 2151.414 of the Revised Code, and the child retains a significant and positive relationship with a parent or relative. Specifically, appellant argues that there was insufficient proof for the court to find by clear and convincing evidence that the PPLA was in the best interest of the child, and that there was a lack of evidence that appellant has significant physical, mental, or psychological problems that render her incapable of caring for her child. The evidence presented at the hearing established that although a case plan was developed to prepare for reunification, appellant has been less than diligent in following through with her scheduled appointments, counseling sessions, and classes. Appellant forgot to attend a psychological evaluation in March 1999, and a report indicates that she still had not scheduled another evaluation as of December 1999. As of the date of the hearing, she had attended only 2 counseling sessions. A report of the case plan from May 23, 2000 indicates that Mother states her emotional mental distress prevent her from responding to Tajuana's needs. Appellant was given a provisional diagnosis of adjustment disorder with depressed mood. Evidence was presented that Tajuana's behavior had improved and that she had made progress since being placed with a foster family, but that her behavior regressed during visitation with her mother. There was concern by Tajuana's therapist that appellant accused Tajuana's father of physically abusing Tajuana and herself, and that appellant indicated that she suspected Tajuana's father was sexually abusing Tajuana. The therapist terminated joint counseling sessions with appellant and her daughter when she discovered that Tajuana's father was back in the household. Appellant also had to go back to supervised visits with her daughter after this occurred. Considering the evidence presented, we find that the trial court did not abuse its discretion in granting the motion for a PPLA. There is evidence to establish that Tajuana is progressing in foster care and that reunification with her mother at this time will be detrimental to that progress. The evidence also establishes significant physical, mental, or psychological problems, and that there are several areas of concern regarding appellant's ability to parent safely and effectively at this time. Tajuana continues to have a significant relationship with her mother, so that adoption is not appropriate. The evidence at this hearing indicated that the CCDHS planned to continue a case plan that would allow reunification at some point, but that due to slow progress, reunification was not appropriate at the present time. Given this evidence, we find no abuse of discretion in the trial court's decision to grant the motion for a PPLA. Appellant's assignment of error is overruled. All right, so what does this tell us? It tells us that Tajuana may perhaps have past trauma that has not been processed, and that may be manifesting itself in behavior, perhaps today, potentially documented between 2017 and 2022. And it's only I would, I feel like change is a journey. So since 2022, perhaps, even if Tajuana was on a journey of changing, um, you know, but yeah, that the abuse allegations are very heavy. Um, I do think that even if you're on a path of changing, change takes time. Decolonizing is a process. Healing from trauma is a process. So, even though she is committing crimes against others, I do wish her the best in her healing journey. Um, does it excuse what she's doing now? No. Why do I think it explains it? I think she's looking um in places that she shouldn't be for others to take care of her where no one ever has before, perhaps, in a way. Um, and, and do I see potential for rehabilitation? if she were to really go on like a healing, it would be a 5 to 10 year journey. I think, this isn't something you can change overnight. Um, and so I think that's where it is. Like, the people who are impacted by this are never going to see her differently, and I don't think they should have to see her differently. You know what I'm saying? Because of what she did to them. You know what I mean? I need to process this more. And if I do during this live stream, then I'll try to connect those dots a little bit better. But I just kind of want to check out how I know she's in Bismarck, North Dakota. I believe I found her Facebook profile for Tajuana, um, going by Harley Tajuana Quinn. Um, I believe this is the same person from the mugshot that we saw before previously. I believe this could potentially be the same person. The mugshot that we saw, was a thing. There is, so we can see like she hasn't always had the full tattoo. So at that time, that would make sense. Where today that would be like more present when we keep going back in the timeline. All of those tattoos aren't there um, in some of these photos. So whether that's makeup or what, but I do believe that this person is uh, Tajuana based on that mugshot that we saw previously. Um, and if I am wrong on that, I will issue a correction. And I just kind of want to reflect. So, how is this similar to the GRB case? Well, look at these dogs here. You know what that reminds me of? For some reason, it just reminded me of the husky tattoos that GRB got with Ken. This image right here, I don't know why it did, just the way, just something about how it has the heads of two dogs and the fur kind of going just right, and then the dogs looking at each other. They're different dogs. I don't know the name of this breed. I think this might be a wolf, actually. Well, is a wolf a dog? They're a canine variety family. Um, you know what I'm saying? But that reminded me, that stuck out to me. In her profile photo, there's like a dog. There's, seems to be like a lot of, like a whole dog thing. Gypsy Rose, Blanchard. Oh, I said I was going to use her name, but then I was reading it. GRB. Oof, my bad. I'm trying not to, I don't want to I find myself using her name and I think I use it because of how I'm hearing it so often in society. And that speaks to how the normalization of the words we're around and the tolerance of it leads to the perpetuation of it, right? So look at me slipping up and saying the slur, and I don't want to. I want to stick to GRB. So yeah, she's known for leaving her dog Pitsy with Ryan, and she's known for with her ex-husband. They got a dog together, and she left the dog with him, and she's known for getting tattoos with her current baby dad, father of her child, allegedly, we think, matching husky tattoos, which is interesting to me. So there seems to be this like dog similarity that they have. Physical abuse, GRB, alleged comes from. I do believe. I don't know the extent to which there is truth in some of the things that GRB says because of the ways that she can be caught on slipping up on lies. But I do believe, based on certain things, that to a certain point that she has been abused. Um, and so I think that's another commonality. Both of them have been accused of fraud. I think that's another interesting commonality. Um, GRB's been accused of fraud as a defamation. Well, she's accusing content creator who's accusing them of fraud of defamation. I can't speak. Do you know what the fuck I'm trying to say? Um, but yeah, uh, she's known for allegedly with her mom having lied about her age and stuff and sickness in order to get money and things from others. in that whole case. So that's like a whole nother thing. And then GRB recently claimed Chitty Matcha. I'm going to try and find the TikTok. I didn't find. Okay, I know I have this link somewhere real quick. I'm going to go look for that link, but I remember her claiming that she's trying to claim that she was part Chitty Matcha, that she was part um
There's a point at which
see where it says Biloxi Chitimacha? Because she was claiming that. She said the Biloxi Chitimacha tribe in an interview. Ken was there. Did they wipe that video from the internet? I feel so gaslit. Hold on, because let me go look on TikTok real quick. So on TikTok, I had made a comment saying I need someone from the Chitimacha tribe. Let me know. Um, and it got likes. Oh, now you don't want to show me all my notifications. Wow. I miss the days that used to show me all of my notifications. Hold on. Will it if I go on phone? Let's check this out. I know I look crazy. I apologize for not being better prepared. I thought the search result would show me the evidence, but now I'm not seeing the evidence. Um, I know. I feel gaslit now. I might do a whole fucking follow up. Alright, I'm going to go find the video, link the video in the description, and I might do one follow up video on this whole concept just where I show proof of GRB claiming this because I feel gaslit. But okay, I feel like enough people had to have seen that to know that I'm not crazy and that that's not defamation. She totally did try to claim that she was Chitty Matcha. I just can't I believe she definitely tried to claim she was native. I think she tried to claim she was Chitty Matcha. I just can't find the proof right now, but I'm gonna go fucking look for it. Um and I bet I'll find it eventually. So yeah, I'm gonna look for it and then I'll do a follow up on that. But um Harley Tawana Quinn is also claiming here to be Wild Oglala. For those who don't know, that's referencing the Lakota people. And if you're Lakota, I apologize for my Wasichu Aswa. Is that appropriate? Is that appropriate? I apologize for my role in contributing to harm here. Fucking what? In terms of like, I don't know, like I'm mixed descent, but I'm also like, if you want to be technical, I'm a descendian. I mean, I guess my dad's not, but I am. Does that make sense in a way? And I say, how is my dad not, but I am because I look white and my dad doesn't. That's what I'm saying. So right here, they're saying like, so Che Jem posted when she finds out you're indigenous and starts showing you all her crystals, and she posted and she reposted that. Was there was another post I thought I saw where it looked like I felt like she was claiming indigenous ancestry. Let me see. And then if you notice here, the two bottom right there, um, I I do not think I don't know if she has ancestry for lots to not be cultural appropriation, but you know, as I mentioned, I'm mixed descent, you know, so I totally understand how someone can be white presenting, mixed descent, and have the actual ancestry of a culture. Um, my dad is Powhatan descent. Okay, so another thing she posted was it has like a hand with a feather. It's a blue bracelet on it, and like a orange and yellow diamond with a red um like line at the bottom, which are sacred colors in my opinion to some native communities. Um, it says I'm the result of all of my ancestors, and the feather is also a sign in native community to represent being indigenous. Um, so yeah, it's another thing that uh, shared. And so I don't know if this person is Lakota. I have some Lakota friends. I don't know if it's appropriate to tokenize my Lakota friends in this situation. But I did ask my Lakota friends if um, they knew she's sharing native vibes content, as well as Indian country content. Um, I've asked my Lakota friends if they knew her. The ones that even know her, no one was able to necessarily claim that they knew her lineage or knew of any connection to her their tribe. Um, so if you're Lakota and you do know that this is a Lakota woman, please let me know because I do not want to be invalidating one of your own in any way, shape, or form. I am just saying I don't know if she's Lakota or not. Whenever she put Wild Oglala as her description, to me that looks like she could be claiming Lakota in my opinion. She also had a cover photo of Native woman with a eagle in my opinion. I believe that's what this depicts. She also has another cover photo where she depicts a teepee. In my opinion, both of these cover photos look like stereotypical AI generated images, in my opinion, but I don't know where those images are from, so I deeply apologize if I am wrong. Um, Sharing MMIW alert, that is good though. Even if you're pretending, it's at least you're sharing the MMIW. But if you're not, if if you're descendant like me, or if you're actually native, I am so sorry. So sorry. Perhaps I'm being harmful with that ideology. I think it's only because like native community is so small. Even if I don't know someone who's Powhatan, if we talk long enough, we're gonna find out if not who we know in common, who our common ancestor are. Because by lineage, to be Powhatan, we have the common ancestry, or you're not Powhatan. Um, and so we talk long enough, we find who's our common ancestor and or which Powhatan people in real life do we know or are connected to. I was not, and so I when I was talking to my Lakota community, I was not able to um connect. No one was able to connect her to any of their relatives. Um, and so I'm not trying to be harmful. I apologize if my wording is harmful, but between noticing that and also noticing in this image here, you see where you have the wire wrapping around a lock. This hair type as well, it's obviously not meant for her hair type. Um, that, in my opinion, is cultural appropriation. Um, if she doesn't have black ancestry. And so these are just two concerns of I question if there's cultural appropriation involved here. Um and so yeah, and then another post here it says indigenous excellence, I'm so here for it. Us natives out here winning finally hashtag seventh generation with Echo from Stella Standing Bear photo. Um, so right here, it looks like she's trying to claim to be native, in my opinion. And so right here, you're claiming to be native, and then, but I'm gonna just let you know, like this type of hairstyle isn't, in my opinion, of it's not if you're claiming Lakota, in my opinion, look, this isn't a Lakota hairstyle. That's not from Lakota culture, in my opinion. I apologize so much if I'm wrong please correct me, somebody. But yeah, I do question. There seems to be some confusion here with the cultural appropriation and cultural mismatch. And I just want to pull back up. Let me get this again. I'm gonna pull back up one more time the mugshot real quick, just so we can do a comparison, and you can gauge for yourself whether or not um, you think this is the same person. Um, and so this is the what we were looking at here, and this is who I think is the same person. They're both going by the name Tajuana here. I believe they are the same person because, in my opinion, um, well, the birth date here matched the birthday on that previous case law where we looked at the Suzanne, where we looked at the child abuse case. The birth dates match along with the names, along with the public record of locations. It all matches. In regards to the profile here, in my opinion, the photo for me looks very the if it's just this coincidence they just happen to have the same name. The oopsie, I accidentally clicked her stories. Damn, now she knows I'm fucking looking at her. That's embarrassing for me. How much does that suck for me? Wow, that really does suck. It's like whenever you're trying to look at somebody's profile and accidentally like it. I'm really hoping she doesn't look at who viewed that story before it expires. How embarrassing for me. Anyway, um, fucking, so, in my opinion, I believe this is the same person. The eyebrows look very similar, in my opinion. Um, and I think it's just a matter of angle where we're getting the difference here. Like, but the nose and the mouth do look like, particularly like the tip, it's just a facial expression. And then she also, I have this too. We both have, like, mine isn't, I think hers may be more pronounced than mine. There's like a word for it, but I don't know what it's called. But mine does like this little line here too. So these are reasons I have for believing this is the same person. This is why I believe this person is now in North Dakota, Bismarck. And I just want to make that the public aware. You know, if you are in North Dakota, if you're in Bismarck, North Dakota, and this person is around you, I just want you to reflect on value alignment. You know what I'm saying? Like, do you feel safe with someone around you if you know that they have not only a history of stealing over $5,000 from somebody else, but also um, they weren't even made to pay back that money, and they've since then been arrested related to being inebriated, and so you don't know what the state of their mind could be now. Um, do you feel safe in that particular situation? I think that's what I hope you reflect on. Um, for me, it's a pretty serious discussion. When we think of value alignment in society, when we think of normalization of social issues, when we think of how did we get here? How did we go from 0 to 100? How did we get from point A to point B? What happened in someone's journey for them to make the decisions they make? You know what I'm saying? I think this is an interesting reflection when we think on what are we comfortable engaging with in our community, and is the outcome of what is happening in society in situations like this ethical, and how can we rectify situation when harm is being done to others. You know what I'm saying? These are all things that I think we should reflect on. I hope you're reflecting on these situations. So yeah, uh, I feel like it's important to consider what happened in childhood, not because like I have my own abuse situation, so I'm not sitting here like, okay, she was abused, so that's why she's doing the shit she did now. I did not mean to be that way at all. So if I came off that way, I just want to apologize heavily for that, because I've been abused. I don't think, okay, just because someone's been abused, you're gonna go do some fucked up shit to others and that's the excuse. Hell no, that's not what I was saying. Where I was going with that, by the way, was reflecting on not only seeing similarities between Tajuana Thornton or Tajuana Thomas and the GRB situation, but also understanding how when someone is growing up in an environment where certain actions are what they are, all they ever know, that, in my opinion, impacts their brains to why are they doing the things they do in the future? Like, how were they taught to be? You know what I'm saying? It's more of like the environmental factors that led her to go from A to B, because I don't believe that people just go stealing overnight. You know, I believe, in my opinion, that there are situations that lead up to an escalation of events to where this then becomes the outcome. So I do think it's interesting that in this case there is that legal documentation between 2001 to 2017 to 2022, regarding this person's experience, being immersed in situations of crime, from her parents to herself. um, I think that speaks to, you know, on some levels, when we think about crime, typically I'm thinking of it in terms of mass incarceration and criminalization of others. So for me, it feels off to be on this side of the argument, where I'm saying, okay, well, even if I'm against mass incarceration and the criminalization of human beings, how can we work within the system available to us to create justice when harm is done, and not only to actually ensure that there is justice served, but also, um, how, what do we do with people who are offending to help them understand truth and reconciliation, to do better, to be changed, to work on themselves? How do we get somebody to be different? Is that possible? Um, you know what I'm saying? This is what I want to think on now, because for me it's like, it's where I struggle all the time in conflict resolution, when I don't have value alignment with human rights issues and I want things to be different. How the fuck do I make things different? Um and in a lot of cases we can't. We just have to set boundaries, and we have to know who to set boundaries for, when to set those boundaries, and why, and do our best to just stay safe, I guess, or I don't know. I don't have the answers. I'm just brainstorming. I'm just questioning. I'm just wondering. I'm just, you know what I'm saying? Screaming, screeching into the void. Um, but yeah, thank you so much for being here. It really means a lot to me that you're reflecting on these issues with me. I hope you have a wonderful day. Be safe, particularly if you are in Bismarck, North Dakota at this time. I am worried if anyone you know is around that person at the time of this live stream. That is where, according to her Facebook profile, she may be located. Um, but she also does have that history in Florida as well as Ohio. So, she's across the United States as far as I know. So everybody be safe. And be safe not only, like in general, like obviously we with mutual aid, I believe in mutual aid. I believe in helping people and doing our best, but at the same time you gotta protect yourself. You know what I'm saying? So on a certain level, as even though it feels inhumane, protect yourself first, because you can't help others if you're not okay. You know what I'm saying? So never do anything for others that will jeopardize you. So how the Gurks let that person into their home like that, be very, very mindful and careful. of who you allow into your home like that. And I hope that's not victim blaming. I'm not trying to be victim blaming. I don't think that it was their fault for this person causing harm to them, because we all know we have all needed that extra hand, which is how, with that vulnerability, that she weaponized that vulnerability to do this, because all human beings need help, and at some point in our life we've all had someone help us, and that's why we're okay. And so I understand, for that reason it is important to give back to community and to help others. But on another level, when it comes to strangers, there's only so much we need to recognize that we can do for others for our own safety. And it's not to cause harm or wish harm on others, but you can't risk yourself on a certain level. But I don't mean that to be victim blaming, because I don't think that would be an appropriate response directly to her victims. I just think it's something that I hope we all consider, in because right now it's very common for mutual aid to be promoted, and a lot of people, we all need help. um, and so I'm also seeing, in my opinion, I feel like I'm seeing too, with that rise, a lot of people also fall into scams and frauds and fucked up situations where they're fucked over because they were actually just trying to help somebody. You know what I'm saying? So we gotta be careful. So yeah, don't not help someone just because some people are assholes. But at the same time, be very, very careful. And if something does happen to you, it's not your fault, okay? Like, them using you being a good person against you, don't let that make you less of a good person. That's not your fault. It doesn't make you any less doing, you know what I mean? Like, you were doing all you could. You know what I'm saying? So yeah, that's all I wanted to say. And if Tajuana watches this live stream, I really hope you reflect on what are you doing to others and what are the consequences of that. And even if in your past other people haven't cared about you, taken care of you, who should have been there for you, do you really want to be the person who is that person to others? And if you are gonna do that, what? No, you know what I mean. Like, that's all I'm saying. Like, for me, it's like I can't get there with that energy. Every human being has a breaking point. We can all get to where we have anger, where we go off on people. Um, but in my opinion, when you're taking out past issues onto people who've done nothing to you, um, where does it end? Where does it stop? When are you gonna address yourself, work on yourself? You know what I'm saying? But yeah. All right. Well, thank you all for being here. I wish Tajuana luck in her healing journey. I hope she takes responsibility and accountability for the harm she's causing others. I wish Tajuana's victims luck in their healing journey. I hope that they've gotten paid back, that they get healing, that they get legal action, that if they that they have gotten or can take any legal action available to them. To anybody that's in Tajuana's current community, please reflect on value alignment. Please observe and just pay attention that if she's done this to others, have other people been speaking out about her? Did you believe them? Why don't you? You know what I'm saying? That's all I'm going to say. I appreciate you guys. Thank you so much for being here. I hope you have a great night. And yeah, good night. Thanks for watching. Join the loyalty program at noladeafchild.com/loyalty and check in during live streams to get points for rewards.